Hi everyone! Today I want to talk to you about the process in which a parent in the United States can petition for their child to receive a green card. My name is Yalda Hajavi and I focus my practice primarily on employment-based immigration and family-based immigration. So a few things to know first and foremost, a few definitions I should say. And the first one is what it means to be a child in immigration. So in the immigration law, a child is anyone that's under the age of 21. If you are over the age of 21, you are not considered a child for immigration benefit purposes. Another thing to note and consider is whether you are filing for the petition while the child under the age of 21 is inside the United States or if they are outside of the United States. If they are inside the United States, you'd file what's called the Adjustment of Status application. If they are outside of the United States, you'd consular process that petition with an embassy or consulate at your home country or a third country where the child is residing. So really important to get those two definitions and understandings established up front. What goes into these applications? Well, first you would file what's called the Form I-130 with the Immigration Service, otherwise known as USCIS. In the I-130, you as a parent want to prove to USCIS that you are qualified to file the underlying petition based on the legal permanent resident status that you have. So submitting a copy of your green card or your US passport if you're a US citizen and certificate of naturalization. You also want to establish your relationship to the child. So you want to prove that you are either the biological parent of the child, step parent, or if the child has been adopted, submitting paperwork for that. For a biological parent to child relationship, you would file the birth certificate and everything of course needs to be translated to English for the respective petition. Really important to look at the visa reciprocity table that's published in the Department of State's website, because for each country there are different types of requirements that are required for the format of birth certificate, God forbid a death certificate, a marriage certificate, and so forth. But you want to check the Department of State's website to ensure that the certificate that you're submitting abides with the standards by the Department of State. That is called the Form I-130. So step one, everything that you're filing, birth certificate, your status as a legal permanent resident or US citizen goes into the Form I-130. That is the eligibility portion of the application. If the child is in the United States, you'd file the Adjustment of Status application once the I-130 has been processed. That is called the Form I-485, and you just need to answer a series of questions on this form to prove that the child doesn't have past criminal convictions, medical issues, visa overstays, and all of that. If there are unique circumstances in the case, want to submit evidence to support that as well. You file that form with the Immigration Service or USCIS inside the US if the child is here. If the child is abroad, country or third country, you would file what's called the Form DS-260 and all the accompanying documents and supporting evidence that goes with that with a US consulate abroad. They would have to attend an interview at the consulate, receive their visa, and then hopefully be on their way to the United States. So that's a brief overview of the process in which a parent can petition for a child, otherwise known as someone that's under the age of 21, and a distinction between filing for the petition if you're here in the United States versus if you're abroad. So thank you so much for attending this video today and hope to see you in future videos. Thank you. Bye-bye.